Good afternoon, everybody. Welcome to Migration Down Under's webinar on the immigration update post 1 July. For those of you who are not aware, my name is Julie Williams. I'm a registered migration agent. I've been around for a while and I work with Migration Down Under, a company that I formed 25 years ago. And we've got quite a team of us now with some very experienced migration agents. Just a disclaimer that the advice that I'm providing today is just general advice, and we don't actually, it's not anything specific to anybody's individual needs. So if you do require some individual attention, then don't hesitate in getting in touch with us directly. So without further ado, the agenda today, we're going to be looking at the post 1 July changes that are affecting the employer-sponsored visas. I know a few of you here today are interested in that space. Also looking at other changes that have affected other skilled visa classes that still may or may not affect employers as well as employees. Looking at the skills in demand overview, as well as future changes and what we know about those future changes. And when I talk about future changes, the changes that are occurring from November this year. And then we'll have time for questions at the end. So feel free to jump in the chat box and put any questions you may have in there. And then I will come back and then we'll answer the questions at the end of the session. So what has changed? Some of you who are attending may already be aware of this through our newsletters that we provide you and our conversations with each of you, but the 457, the 482, believe it or not, there's still a few 457s out there, 494, they're all employer-sponsored visas, and they have a condition that used to prevent the employees moving freely from one employer to another without first being nominated and sponsored. That restriction or limitation has been removed as of the 1st of July, which allows a lot more flexibility and portability for those employees, as well as employers as well. It's to stop employees that were possibly being exploited, weren't happy in their workplace, maybe were made redundant unexpectedly, and previously only had 60 days to be able to find a new employer to sponsor and nominate them if they're not already a sponsor. Otherwise, a sponsor would only just need to have a nomination to be able to transfer their employment over. Also, that condition didn't allow the actual individual to commence work until the approval of the nomination. And for some, that was a delay. It has been improving. This year has seen a big turnaround with the nomination approvals, where a lot are now being auto-granted, but you still had the delay if you had to advertise the position. So what does that mean for individuals and employers alike? Well, individuals can cease work in the knowledge that for 180 days or 6 months, they're able to work wherever and for whomever they wish. They don't have to work in their nominated occupation. And the reason for this is perhaps, for example, they're a software engineer and cannot find employment straight away as a software engineer, or there is a delay in starting that new role. Everybody has rent to pay or mortgages to pay or food to buy, just everyday living expenses. The individuals were restricted because they had no way to be able to financially afford to not be employed. And that stops anybody, I guess, not being able to work whilst finding that suitable employment. So a software engineer could, go and work at Woolworths, packing shelves. They can do whatever they like. It just gives them a means to an end while they're waiting to find a suitable employer. What does that mean for employers? Well, it's good news because you can start employing people that you find through your recruitment process to commence working with you straight away without having to wait for the nomination to be approved. It's almost like using that as a probation period, making certain that that person is somebody that you wish to employ beyond that 180 days, and you're seeking to sponsor. So it gives you a little bit more flexibility that you don't have to rush into it. Also giving you that time to be able to onboard them correctly and have them straight away rather than being delayed. Now, what does it mean by, they can work do this for up to 365 days? Well, what happens, a 482 visa holder may have a 2-year visa, a 4-year visa, depending on their occupation. For the duration of that visa validity, they can not be employed for any of their sponsoring employer for no greater than 365 days in total, but you can only do it for a maximum of 180 days. The requirement and onus is also on the employer to make sure that they are monitoring this and not employing them beyond their 180 days. So they can only work for 180 days in one spell. And the reason that there is at 365 days, even though 2 lots of 180 don't actually add up, that's the government for you. The 365 days just means that if an employer is sponsored by a second employer, then if it doesn't turn out, they have another 180 days to once again find alternative sponsor and employer. So good news for a lot of people out there that it allows you that more flexibility from both sides. And as I mentioned, you can work for anyone in that period in any particular occupation. If you wish to sponsor them beyond employ them beyond the 180 days, then you still have to go through the nomination. And if you're not already a business sponsor, lodge a business sponsorship. What else is happening in the space of employer-sponsored? The Migration Amendment Bill has been strengthened. It's actually now the Migration Amendment Act, and that increases the fines payable under infringement notices, introduces infringement notices for violations of introduced civil penalty provisions. And a lot of employers are going, oh, that's really not going to affect me. But the other thing it also does is boosting not only employer compliance by imposing stricter penalties, but also monitoring. And auditing and monitoring by the government was always there, and it stopped probably about 4 or 5 years ago now. And they are reintroducing that. They're putting more more people in that area, throwing more money towards that area of the Department of Home Affairs. So you do need to make certain that you are compliant with not only the individuals you're sponsoring, but also any temporary skilled worker that you're employing, whether that's a working holiday maker, whether that's somebody on a student visa, whether that's somebody on a 485 graduate visa. You do have to make certain that you're keeping adequate records and employing them under the conditions of their visa. So that is something that employers should actually look out for. ATO, Department of Home Affairs data matching, that has been around for a little while now. It's just looking at being strengthened there, making certain that employers are actually paying their skilled workers, such as the 482, 494 holders, the salary that they said in the nomination application that they are going to intend to be paying. Also, their government fee increases. I think a lot of you are already aware of that. It's increased around, on average, about 3%. It hasn't increased fees for the actual business sponsorship or the Skills Australia funding fees or the business nomination. Those fees haven't increased, but visa applicant fees have increased. The new workplace justice visa, it's coming under the 408 stream. The 408 visa has a number of different categories under it, And the new workplace justice visa is going to be rolling out later this year. The government and the Department of Home Affairs have advised they're going to be making more announcements on this on the 25th of July. And what this new workplace justice visa is, it's for individuals that are having problems with perhaps their employer, are being exploited and have no other means to be able to remain here in Australia. And it's to stop the threat of it's not just employers, but individuals holding threats over visa applicants to say, well, we're going to cancel your visa if you report us for any wrongdoing. So it's a really important visa to have because sadly there is a lot of exploitation out there. The other things that have changed, the temporary skilled income threshold has increased from 70,000 to 73,150. That's for all new visa applications from the 1st of July. So if you've got 482 visa holders that had a visa prior to July and are perhaps earning less than that, that's not going to be a problem unless you're looking at sponsoring them for a further 482 visa or sponsoring them for permanent residency on a 186 visa. They will have to have not only meet the market rate salary for their occupation, but also have a salary above the TSMIT or the temporary skilled income, migration income threshold. But be mindful as well that as part of the monitoring that they're going to be looking at is making certain everybody is being paid the market rate salary. So whilst you may have 482 visa holders that the increase doesn't currently affect, you still have to make certain that they're being paid the equivalent to the market rate. A lot of people get confused with the market rate salary and the TSMIT, what the difference is there. The market rate salary is the market rate or what the market dictates that occupation salary to be. That may be determined by in-house market salary matching. It might be that you have an employee already in that position that you're looking at filling another position with a skilled migrant. The market rate might be dictated by external market data if you don't have anybody working with you in that same occupation. And the market rate for the occupation that going to be and not person you're going to be nominating must both, not only the individual's salary, but the market rate, they must be both above that minimum threshold of 73,150. So if you've got, say, chefs, for example, and the market rate is 70,000, that's not going to allow you to be able to sponsor somebody and have an approval of that nomination. The Fair Work high income threshold has increased to 175,000. Probably wondering, well, how does that affect me or how does that affect my employees? It's more so if you are sponsoring people on a 482 or a 494 and they are above the age of 45 and you're seeking to sponsor them for permanent residency, as long as they are earning a salary of 175,000 or above and have done so consistently for their visa period, then they can have a waiver as far as the age restriction is required for permanent residency employer-sponsored 186. Superannuation guarantee rate has increased. Employers will know that. Individuals on the webinar may not be aware that that has increased to 11.5% from the 1st of July. And when you are sponsoring people, you need to remember that the TSMIT or the temporary skilled migration income threshold doesn't include superannuation. So whatever you're offering, you need to offer a base of a minimum of 73,150 plus the superannuation. Again, I don't advise just matching the TSMIT because then it proves very difficult to show that you have got somebody else on that exact fee. Because if the market rate is below that $73,150, even if it's just by $50, it's not going to meet the requirements. There are restrictions for certain visa holders applying for student visas onshore now. There's been a lot in the news about the education sector and students. There is a lot of students still in Australia that have been on a student visa for 10 years or more, and the government are trying to sort of stop that to enable them to perhaps get onto another type of visa, or stop people using the student visa to just placate their stay here in Australia whilst trying to work out what other visa that they could apply for a more long-term stay. So anyone on a visitor visa can't apply for a student visa here in Australia. Anyone on a temporary graduate visa also can't apply for a student visa. And there's a few other conditions as well to that. Business Innovation and Investment Program has closed. That is looking at being replaced later in the year by the National Innovation Visa. We haven't had any further information about the National Innovation Visa, but it's likely to be replacing also the global talent, which is looking for highly skilled, globally recognised individuals who are internationally renowned in their particular profession. That is in demand here in Australia. So they'll be focusing on things like, high-level cybersecurity, a lot of the fintech type occupations, space, things like that, that are quite internationally renowned, and trying to compete with the globe to seek those talents here in Australia. So what's not changed from the 1st of July? Sponsorship obligations have remained unchanged. So you, as the employer, still need to meet all your sponsorship obligations. Some of the more simple ones that often sponsors, employers forget. If you update directors, which sometimes, if you're a large organisation, can happen annually on 1st of July or whenever your financial year may be, you have to update and notify the department within 28 days of any change in directors in the business. If you relocate, move, change addresses, then you also do need to notify the department of that change of address. Employees leaving, a lot of people forget to either notify their registered migration agent or notify to be able to then notify the department on their behalf that somebody that they are sponsoring on a 482 or a 494 visa has ceased employment. You do have to notify the department. You don't have to notify them if they've already got permanent residency and they're on a 186, but you do need to notify them if they cease employment. The other thing too that many employers get caught out with, sometimes you are obliged to pay reasonable return travel for sponsored workers and any family members included on that 482 visa, only if you get the request in writing from your employee. And it's not all their goods and belongings, it's only the individual's costs to travel costs to return to their home country or closest destination that they're going to. So what we know so far as future developments in November, the 482 visa is going to be replaced. I know it's only been out since, 2017. For some of you, that may seem such a long time. But when you've been in this space and seen the 482, it used to be the 417, I think, or 47. I can't remember, but there was another one before the 457, and now it's the 482, and they're going to rebrand it again. And this is due to the government overhauling the temporary skilled migration program to be more in line with the needs of businesses as well as individuals in the Australian economy. And this was all through consultation that they've had externally, and some of that consultation is still ongoing, especially with the essential skills pathway. So from November, we don't have a clear date of when that's happening. They're just saying the end of the year, which generally speaking, new updates do tend to come in, if they haven't already, in July, in November. So obviously we will continue to update you with any further developments. But basically they're going to be looking at 3 streams in the skills and demand visa. It's a temporary visa, replacing the 482. You've got the specialist skills pathway, attracting the top talent and highly skilled professionals. Those occupations or those people will be expected to be paid at least a base salary of 135,000 plus the super, and the processing time frames for those are expected to be done in days. And then you've got the core skills pathway, which I think is what most of the occupations are going to fall under and is going to look very similar to the current 482. There is going to be a newly established core skill occupation list, which was, I say, currently in consultation. It is any further paper and submissions that has closed, but it still is in the consultation phase. They've reached out to everybody publicly, a lot of associations such as for example, the Hospitality Association has been involved. The health education associations have all been involved in that, looking at the core skill occupation list. Jobs and Skills Australia are the ones that are doing that. They're looking at addressing the targeted workforce shortages, and the salary is going to be meeting the current TISMET. So very much similar to what the current 482 looks like. And I think the majority of occupations are going to continue under. And then there's the essential skills pathway. The essential skills pathway is going to be exactly what it suggests, the essential skills, and that is in hospitality, that is in health, education, and in occupations that you can't necessarily currently sponsor because they're not on the main occupation list for the 482 visa. So you're looking at perhaps personal care assistants within the healthcare profession. You're looking at more lower skilled occupations in the hospitality where they can't fill, because at the moment hospitality, it really is only restaurant manager, chef and cook. So that's going to be expanded, and also areas of construction as well as areas of what was the other one that I was thinking of? Education, which I think I've already said. That's going to probably reflect a little bit what is happening now, but with a lot more detail and clarity around it, and hopefully ease of access, because that has been the main thing that has prevented many employers to look into the Dharma and the labour market, the labour agreements, because they are so time consuming, but also they take such long times to make decisions. The Dharma, for anyone that doesn't know, is the Designated Area Migration Agreement. And there is one in New South Wales under the Arana Dharma, which is in out near Dubbo. There's a newly formed one, Western Australia, that covers the whole state of Western Australia. South Australia's always had one that's just covered the entire state. Queensland, there's the far north Queensland one. So there's going to be a lot more, I think, designated area migration agreements, or DARMAs. And the LA, or the labour agreement, is for industry specific, or such as the aged care labour agreement that they've got out there at the moment. And they're looking at developing those more. And that's still in consultation. So we haven't had anything further. And it'll also be in collaboration with the states and territories at the moment, because they are the ones that can see where within their regions are the skills required. And each region and each state and territory obviously has different requirements depending on the area that they're in. Just a reminder, a lot of individuals who want to apply for a Dharma. It's not for individuals. It's only for employers, but it's for individuals to be sponsored under that way if they're being offered a position by an employer that can access that. Northern Territory Dharma is one that's been around for a long time. That also covers the whole state, and it covers a lot of occupations that are not on what would be the core skills pathway or currently the 482. Timelines, the occupation list that I was mentioning, that has now closed as far as submissions, and Jobs and Skills Australia is working on that. And I guess we wait with bated breath as to the announcement of how that new occupation list will look like. From November, they announced this a lot earlier than July, just recently, but there will be a reduced work experience requirement for 482 visa holders. At the moment, the requirement is that they've got the relevant qualification plus a minimum 2 years post-qualification experience. It must be full-time work experience. It must be paid. Full-time experience is 35 hours. And sometimes, depending on the occupation, in lieu of a tertiary qualification, they can substitute that with relevant work experience. If it's a diploma or lower, it's usually 3 years. If it's a degree, it can be 5 years. That's not for all occupations, just some can have it in lieu of a formal qualification. But as of November, you only have to have 1 year. We do, in this profession, find it very unusual that they've increased the salary requirement, yes, yet they've reduced the level of experience. So it seems to contradict what they're trying to achieve as far as having the 482 visa as for a highly skilled individuals, and very difficult to justify someone's highly skilled with only 1 year's experience. But then again, it depends, I guess, on the occupation. November is the new talent and innovation visa that I briefly mentioned, that is coming into effect. That will replace the global talent as well as the business innovation visa. We don't have any further details or information as to how that's going to look and what that criteria is, but stay tuned and we'll keep you updated with that. They are also going to be developing a public register of approved employers and strengthen the integrity of the approved sponsor process. How that's looking, I'm not sure. And I guess having a public register of approved employers may also attract individuals that are going to be seeking employment, and it could help with matching a temporary skilled worker up with you as the employer. So now we're at the time for questions. I did see a couple of hands raised through that, but I'm not sure if anyone has any questions. No questions at this stage. I'd like to think that I can take that as I've answered everybody's questions or interests as far as what they wanted to hear today. Look, we do have regular webinars when there are any updates. Sometimes we may just have ad hoc webinars. We are looking at having one specifically on just employer compliance in the next little while. So stay tuned. We'll put those details up on our website and promote them in the usual social media channels. But thank you so much today for joining us. If you do want some further information, and you're not receiving our newsletters, then please subscribe to our newsletters. Go visit our website. You'll notice that for those that have known us for a while, our website has been updated. We're still working through it and tweaking it slightly, but it is a new look website and you'll find a lot of information there. You can always phone us or email us. We've got our head office here in Sydney, otherwise an office also in Melbourne. So have a wonderful afternoon, everybody. Thank you for joining us. And I understand that there is a recording of this webinar if you do wish to listen to a recording afterwards. Thank you very much.